Hi, everybody. Welcome to issue spotting for debt collection. I guess for non-consumer attorneys should have been added in there. Uh, we're going to go through some of the basic general things that we see that we think non-consumer attorneys might want to refer out to consumer attorneys. And feel free to ask us questions as we're going. Both of us are happy to go off on tangents and figure out anything. Although I know figuring out if a question's been asked is sometimes difficult, so we will do our best to figure that out. And next slide. All right, so this is the agenda. We're going to go over what is debt collection, issues, spotting the debt collection issues, like I mentioned, and what are some of the next steps after you do spot those issues. Next slide. So first thing, what is debt collection? There's the general obvious thing. It's people trying to get money from you in a variety of different ways. The main thing that we see with debt collection is going to be lawsuits. That's at least with our team. Before it gets to a lawsuit, that's actually on the next page. There's a bunch of things that they'll do. And we'll also have the kind of chronology of debt collection on the next page. Some of the common ones I can see: credit cards, rent, medical debt, student loans, mortgages, also auto loans. We see that a lot when there's a repossession. Um, the auto loans and medical debt can be a little more fun because there are additional hoops that they have to jump through in order to get a judgment on those two. So always be on the lookout for those because we do have a little better chance of winning those cases than we do with your typical credit card cases. Next slide. So this, like I said, is the chronology of the debt collection process. First thing, of course, is the consumer debtor misses a payment, and Chase, Wells Fargo, whoever, they don't like that. They want to get their money, and so they're going to do different things. They're going to start sending out letters. They're going to possibly make some phone calls and do what they can to essentially harass the consumer to try and get them to make the payments. Um, the days can vary. So although we put how long it takes before they start that, different banks will have different timelines on that. And even within the same banks, we see different timelines depending on a variety of different things. So after they've gone through trying to call and send letters and given up on that, they will send it off to collections. Sometimes they'll do it to an internal collections. Sometimes at this point, they'll give up and charge it off and send it to a debt buyer. The interesting thing with charge off, it took me a while to learn this, and most of our clients are often confused by this. Charge off is just a term for the IRS, really. It basically is saying we don't think we can collect this anymore, and so we want to get a credit when we're paying our taxes. It does not mean that they're forgiving the debt or that they're completely giving up on it. They're just saying we want to get our tax credit for this. Um, so that would be the next step. If they do send it to a debt collector, that's when the fun starts, because debt collectors will start harassing in a variety of different ways with phone calls. They can now do emails. They can also go onto social media and send messages via Facebook. Um, they're not going to post anything onto a social media site because of the FDCPA and Rosenthal Act, which we'll get into a little bit later. So they're not going to make it public, but they can do a variety of different things that they didn't used to be able to do. It used to be just phone calls. Um, there's also been some limits to the amount of phone calls. They can only do, I believe, 7 phone calls per week now. They can do that all in one day if they want to. Typically, they won't. They'll spread it out, do it at different times. Um, and there's also some new limits, although with the CFPB potentially being taken down, whether the regulations that the CFPB have started will continue is unsure. So it used to be that they couldn't send those emails, that if they did make a phone call, if they left a message, they had to say that they were a debt collector calling to collect a debt. However, if they did that, that was considered a communication, and there were certain things that they had to say. And if a third party hears that, then they violate it. So there was a kind of a catch-22 on that. You're damned if you do, you're damned if you don't. So the best thing they could do was not leave a message. And regulation regulation X, I can't remember. One of the regulations CFPB recently started about a year or two ago, made it so that they can leave a compliant message in even if a third party hears it. So they're going to continue those letters and phone calls for up to 3 years and 9 months. And at that point, they're going to give up. And they might do it sooner, they might do it later. But somewhere between that time, they're going to get around to filing their lawsuit. And debt collection cases, the vast majority of contracts are a 4-year statute of limitations. So they're going to typically file that within the 4 years of the first missed payment. That's the debt collection process. Next slide. Unless you
All
have
right.
anything
Oh,
to add to
and
that.
Barak, sorry, I wanted
Oh,
to
sorry.
add in that, you may continue, even if you have been sued and you've gotten a judgment against you, you may still continue to get letters and calls and stuff. Just because those things have happened, it doesn't mean that you're off the hook. Although you can take certain actions to stop them from contacting you, which we'll cover later.
Yes. Good addition. Thanks. Um, so impact on your credit report. So debts and collection are considered adverse entries on a credit report. And like it says, can make it harder to get future credit, rent an apartment, and even sometimes jobs will look at your credit report. We'll get a little more into that with the Fair Credit Reporting Act because there are certain limits on what they can do, and they have to be true and accurate, things like that. Um, Typically, the difference between having a judgment and just having the collections on your credit report, not going to be a huge difference. So, if they're looking at that, it's not really going to have a huge difference on your credit score. Um, and one thing that actually didn't cover too much in here, and I think it's just mentioned tangentially, uh, bankruptcy is going to bring your credit score down a little bit more than having just the judgment on your credit report, but it'll actually be able to recover a lot quicker with having the bankruptcy than with having just the collections accounts or the judgment. Financial impact. So the clients can lose money in a variety of ways. Bank accounts, there can be a bank levy. However, there's a new law that went into effect about 2 or 3 years ago. It used to be that judgments would last for 10 years and they could be renewed every 10 years forever. They can now only be renewed one time for 5 years. Also, it was a 10% interest rate. Now the interest rate's only 5%. And the final thing on, not the final thing, the other thing it did on this part is that they can only reduce the bank account down to, I believe right now it's $2,070. That was last year, I think and it's increasing for inflation every year. So that's a nice thing. It used to be that they could take every penny out of the bank account, and then the bank would charge you for the honor of giving them the money that you had. So after you had a bank levy, the client would have a negative amount in their bank account. So that's no longer the case. They've decided that this $2,070 is what a person needs to survive per month. Obviously, that's kind of ridiculous, but still a lot better than what it used to be. Next thing they could do is wage garnishment. They've made this a little more complicated in a good way. There was actually a long MCLE, 1 hour MCLE on this because it's 50% on everything above minimum wage of making minimum wage 40 hours per week. And then, if it's more than that, it's double and everything else. So it's a bit complicated on how to figure that out. And I think it's still they can't take more than 25% from your paycheck each month. Um, And then they can also put a lien on your house. Another thing that changed again 2 or 3 years ago is that it varies depending on the county. Riverside County is the exemption now is about $600,000. San Diego County, of course, and LA County, Orange County are going to be a lot higher than that, although it is capped at a certain amount. But that was a huge difference because it used to be that the maximum exemption on a house was $150,000, and that was only for a married senior couple. And I think they had to be disabled, and it was just crazy. So it's a lot harder to sell a house with a lien based on that nowadays. Um, and then there's just the mental health issues that can come with stress and anxiety and arguments at home and just having to think about that, sleep, everything else. Next slide. So these are the debt collection laws that prohibit debt collectors from doing things that they're not supposed to. Before I got into consumer law, it never occurred to me that there were things debt collectors weren't allowed to do because you figure they call, you owe them money, they're allowed to do that. But there's the FDCPA, Fair Debt Collection Practices Act, is the federal version, and then the Rosenthal Act is the California version, which basically mimics the federal version, with one exception. So under the FDCPA, debt collectors are basically third-party debt collectors. So your Chase, Wells Fargo, Bank of America are not going to be liable under the FDCPA in most situations. Under California, the original debt collectors are liable, and so you can go under them after them. Certain situations where you can't, but the vast majority of times, if they violate FDCPA or Rosenthal Act, well, actually just Rosenthal Act, 'cause there are some differences in them that you can go after them. Um, let's see. The other thing with the Rosenthal Act is that, well, the FDCPA and the Rosenthal Act up until the beginning of the year was only for consumer transactions. So it's worded as on the Rosenthal Act, personal, family, or household purposes. On the FDCPA, it's a little bit longer. I'm not going to read the whole thing because I think I'm already going over on time. But as of January 1st, 2025, Rosenthal Act allowed to include commercial debts as well, up to a certain amount. I believe it's $50,000 of consumer debt for individuals. So that was a nice change because there were a lot of times when people would have a business credit card, but they'd be using it for personal purposes, and then you have to prove that it was used. Very confusing, very annoying when you want to sue the debt collectors. And so this makes it a lot easier to not have to deal with that. And then the final was the California Fair Debt Buying Practices Act, which used to be new. It's not so new anymore. And this has extra rules basically that they have to comply with when they're filing lawsuits and a few other things. The other nice thing about the FDBPA is each of these statutes have a $1,000 statutory penalty maximum. So the client is only going to be able to get, if all three are violated, $3,000. And that's regardless of how many times they violate each act. They can still only get 1,000 total per act. So having the Fair Debt Buyer Practices Act, now they can get 3,000 instead of 2,000 maximum. The one thing that it does have, and the reason that it is a little bit stronger than just the $3,000 is there's an attorney fee provision in each of the statutes. So that's where the big money comes from. Also, there's some interesting things as far as doing it with legal aid. The money that goes to the attorney fees are not taxed, whereas if it's a private attorney, those can be potentially taxed. There's a lot of work being done to change that. But as of this point, it can be problematic for non-legal aid attorneys. Let's see. All right, next slide. And then there's the Fair Credit Reporting Act, and the California version of that which is the California Consumer Credit Reporting Agencies Act. So it's a CCCRAA is the California version. Uh, the FCRA, only the federal version, you can only go after the credit reporting agencies. So typically that your big three is going to be Experian, TransUnion, Equifax. But there are other ones. Anybody who's doing housing knows that there's a lot of housing credit reporting agencies. And if you're trying to get a job, there's credit reporting agencies for jobs. So there are a lot of other ones that you can go after. But Equifax, TransUnion, and Experian are the big three that you're typically going to see involved in this. There are ways to go after the furnishers under the FCRA. Furnishers being again your Wells Fargo, Chase, Bank of America, anybody who's like I said, furnishing the information to the credit reporting agencies. So you have to first send out a dispute and include the furnishers in the dispute. So a little more complicated, but you can essentially go after furnishers if you take those initial steps. With the California version, you don't have to take any of those first steps to go after the furnishers. The other really cool thing, which, to be honest, completely confuses me because it doesn't always work. The FCRA has a specific carve out for California and Massachusetts, allowing us to have our own Fair Credit Reporting Act. However, there are a lot of other states that have it. I don't know how that works, honestly. That's over my head, and I haven't had to deal with it, especially being in California. I know that we can do what we want with the CRA, the CCCRAA as it's written. So that is one of the really cool things about living in California is we can go after furnishers without any issues. I think that's it on those. Next slide, I think, is that it for me? Oh yeah. And how you might see debt collection issues that you'd want to refer to your consumer team or to a consumer team in some other legal aid organization if your office doesn't have it. And so I'll go through these really quick. If clients telling you that they're getting a lot of phone calls from numbers that they don't recognize, good chance that those are debt collectors. One of the things with the FDCPA, I always tell people, go ahead and answer those calls and take really good notes on what they're saying to you. Find out who's calling you, what company, get an address if you can. Don't be afraid of them because they have to treat you with respect and dignity. They can't call you names. They can't lie to you. So you don't have to be afraid of anything. Don't admit to anything when you're talking to them. Just get information from them. You don't want to have them record it because California is a two-party state. So if they don't get permission from the other side to record the call, it's a misdemeanor or potentially a felony. So you don't want to do that. So don't have them record it. Again, they can send messages on social media, direct messages. If they're not paying rent, it's because they're having some issues. If there's a lawsuit filed, obviously, definitely get them in touch with us. Don't let them ignore the lawsuit because then they automatically lose, and that's no fun for anybody. If they're getting their wages garnished, if their bank account's levied, there's something going on that we need to know about. And everything else. And that I think is it for me.
Thanks, Barak. All right, so I'm gonna go through some specific situations where you may see consumer law issues popping up in your practice. I'll start out with housing law. So some of the things that we see a lot at Legal Aid of San Diego, you might see it in terms of dealing with evictions on credit reports. A lot of tenants, they do, a lot of our clients do have evictions on their credit reports. They want to know, how can I get this off my credit report? How long is it going to be on there? things like that. Unfortunately, right now, there's not like a whole lot we can do to get rid of evictions. It's best to see if we can like mask them before they make it onto the credit report, but that's definitely like an issue that we can provide advice on. Another area that we see it come up a lot in housing is tenant screening reports. So you probably have a lot of clients who have gone to an apartment, and they're told, well, you don't qualify for this apartment because we ran your credit, um, and your credit score is really low, something like that. There may be like specialized tenant screening reports that they're using to assign your client a score, and they just use that to deny the person. Um, and the client may have rights under the Fair Credit Reporting Act. If there's like an adverse action taken against them based on a credit report, they may have the right to look at that credit report, get a copy, and dispute that for like future credit reports and stuff. If people are putting inaccurate things on those credit reports, we can provide assistance with like disputing those items. Brock, did you want to jump in?
I did because it reminded me. I was looking at my notes. So yeah, one thing on that, there's the FTC website actually has a really good dispute letter for sending in disputes, whether it's a tenant screening report or any other kind of report. Always send them certified mail return receipt requested. It's a few dollars extra, but having that little green slip, if it ever gets to a lawsuit, is priceless. Um, and then the other thing is credit reporting agencies are held to a standard of maximum possible accuracy, which I can't think of anything else that's higher than that. I mean, that seems to me like, the criminal level of beyond a reasonable doubt. So that's always fun if you are dealing with a credit report and you get to trial and they're held to maximum possible accuracy and get to talk to the jury about that. So that's another thing to keep in mind.
Thanks, Barak. I also, this isn't like really specific to this slide, but I also wanted to mention like credit repair organizations. Generally, those are scams, and they're just sending out like hundreds of like generic letters and stuff. A lot of credit reporting agencies will just ignore that. So it's best whenever possible to send out like an individualized dispute with specific facts about, and supporting documentation. So if anyone needs help with that process, definitely refer to a consumer attorney. Other areas that we see this consumer law stuff pop up a lot, your client may have been served or lost an unlawful detainer. They may have been evicted, and now they owe a bunch of unpaid rent. So you may see debt collection issues pop up, like depending on who's trying to do the collecting. You may have like a collection firm sending them letters, making calls, I don't know, contacting them on Facebook or something. So, sometimes that can lead to claims. And there's also sort of an interesting like area here with the COVID-19 rental debt. So this actually converted into consumer debt. And so, if you have a client with a lot of unpaid rent, there may be things that we can do with that as well. Next slide, we're going to go over interactions with family law, and none of these are like exhaustive. Things may come up in, lots of different things may come up, but these are kind of the common issues that we see. A lot of times you're going to see a lot of conflict over the assignment of debts. A lot of people are going to have co-signer accounts where they were a co-signer. Maybe they have jointly held accounts. And so there's always a lot of questions about, am I going to be on the hook if I'm a co-signer on this account? It was assigned to my partner. It just, or what is my liability if they stop paying? Because a lot of times abusive partners will stop paying. And then the other person on the account is sort of left there to try to pick up the pieces. They might have a debt collection lawsuit filed against them because they are also on the account. And a lot of people think, well, in the divorce decree, that debt was assigned to the other person. So I shouldn't have to do anything with it. Why am I getting sued? And unfortunately, credit card companies, like any accounts where those are jointly held, you still can be sued on those. And so that's like an issue where we can step in and, help them defend like themselves, look at their options, um, or just look into like how they could reduce their liability for any debts that are still remaining. Coerced debt is a big issue that we see. And this is like a situation where it may not be completely obvious that you were forced into, um, well, let me start over because it's a little difficult. But a lot of times, if you have an abusive partner, there may be financial abuse involved. That person may force you to open an account. They may run up the numbers on the account. And that all kind of falls into coerced debt. California has a couple of new laws that were passed recently where, you can identify certain debt as coerced debt on restraining orders. There's also special statutory provisions that can help you try to assign this debt to the abusive partner. Um, so definitely consult with a consumer attorney if you see those things. And then also the effect of bankruptcy being filed by one or both of the parties that may affect how much one party owes or, both of the parties. And I would say also the other thing we would see here is a lot of issues with mortgages. Um, Sometimes only one person is paying the mortgage, only one person is on the title, but the other person may be living in the home. And just figuring out what to do in those situations, that's sometimes difficult. The other person may, like, just like with all these other things, the other person may stop paying, and then you may be heading to foreclosure, have no access to the accounts, things like that. Um, so, those are situations where you could come and talk to a consumer attorney. Brock, you want to add anything on this slide?
Yeah, bankruptcy, when a bankruptcy is filed just by one party, one of the really interesting things about that is during the marriage, all of the community property debts are covered by that bankruptcy for the other party. If the one who files the bankruptcy gets divorced or dies, then all of those debts come back again for the party who did not file a bankruptcy. So it's a little quirk and a little interesting, but that's something to think about and keep up with.
Yeah, yeah. And I would also look for issues between separation and divorce because a lot of like weird things tend to happen between there where they're kind of like in a no man's land where things haven't been assigned out yet between the parties, but um like technically they're not together anymore. So that's definitely like a period of time where you want to be really monitoring the finances. Immigration law. So also in immigration law, you might see coerced debt if intimate partner violence is present. There might be identity theft issues if someone's passport was taken or other immigration documents. And similar with like debt bondage or other trafficking related debts, you may see issues with that. Let's see here. Medical debt, or sorry, health law. So medical debt, you can be sued on medical debt. A lot of my clients are shocked that they're being sued on a debt from a hospital. And I've seen lawsuits for amounts as low as $600. So just because they're not incurring thousands of dollars in medical debt doesn't mean that someone won't try to come after them. Um, so you may see it as a debt collection lawsuit. A lot of times they're going to get collection letters. Um, the one thing to keep in mind with medical debt is that there are specific protections for people who owe medical debt, in terms of whether they can be foreclosed on, things like that. So that's definitely something to keep in mind. Another thing you should keep in mind is a lot of our clients will qualify for charity care. So most hospitals are required to maintain charity care policies that can bring the amounts that you owe, like really, really low or down to zero. So that's not something that's advertised by the hospitals. I think a lot of times it's in really small print. So that's something that you can look into if you have clients who have big, big medical bills. Those are definitely things that generally can be negotiated. And even if they've been sued, that's something that they can look into and pursue. Another way that we see medical debt pop up is on credit reports. A lot of people will have very big medical debts. There's been efforts to get medical debt off of credit reports, but I think that's kind of up in the air right now just due to all the changes in various rules and stuff like that. So you may still see some medical debts on there. I forget, is it there? I think there's a rule right now that says if it's below a certain amount, the major credit reporting companies will not include it on your credit report.
Right.
Um,
But they are trying to get rid of that. And this is again where it gets interesting with the FCRA and the CCCRAA, because the carve out for California and Massachusetts was a very specific one for that specific time. And California has added it that medical debts cannot be on credit reports anymore. So this is, like I said, one thing where I'm not completely sure of how California is able to add something else. And a lot of other states have done this too, that medical debts cannot be included. Um, and then one other thing on charity care I want to mention is you can apply for charity care at any time. There are some time limits on certain things, but the application for charity care, there's no time limit on it. And they also California recently had one that if you do apply and get granted, there's certain situations where they actually have to pay you back any money that you've already paid into it with interest. So it's a pretty powerful statute.
yeah, there's a lot of great stuff out there in terms of charity care. So it's definitely something you should look into. There's a website maintained by the state with a list of all charity care policies. So, you should, I think like you can usually find it if you Google, but that's if anybody's interested in that, feel free to reach out to me or Barak. I'm just going to volunteer you. And I'm sure we can get you that list. And then lastly, I would say credit cards, medical and dental credit cards. So we've seen companies like Care Credit. And usually, like, you're going to see this, like, if someone's getting sued on a Care Credit account. Um, and a lot of times, like, the way that people are convinced to sign up for these, they might be in the dentist chair getting their treatment or something, and they're being forced to sign these documents to have treatment continued. Um, they may not speak English, but they're being forced to sign it. They have like impromptu translators at a dental office or something. Like maybe the receptionist is trying to explain the terms of this credit application to you. So those are all things like where if you see a Care Credit account or something similar, because there's a lot of companies out there, it might be worth taking a second look to see if there's anything you can do with that. All right, and then we're kind of switch gears and talk about what information that you generally want to gather when you're trying to evaluate whether this is something that you want to send to a consumer attorney, or just, in general, if is this something that we can do something with. So you want to understand the type of the debt, the age of the debt, current company or agency trying to collect, the stage of collections, and the overall amount. So the type of the debt Barak talked about before, generally with like credit cards and stuff, you're looking at a 4-year statute of limitations. With like auto deficiency balances, which is like the balance remaining after they repossess the car and sell it. You may have additional protections through the Reslevering Act, the Commercial Code. Also with medical debt, we talked about some like additional protections you may have there. Student loans, sometimes like you'll apply a different statute of limitations. You may be stuck with like a 6-year statute of limitations because they consider it a promissory note. So it's really important to look at the type of the debt. The next part, the age of the debt. So that really comes into play in terms of the statute of limitations. Usually, like when we're looking at these debts, we're looking at the date of last payment and starting the statute of limitations from there. So if someone made their last payment 4 years ago and they're being sued 5 years after that, that might be a claim that they have because they're being sued past the statute of limitations. It's a debt that they're not legally able to try to collect on in that way. Other things like the current company or agency trying to collect, you might have different rights based on whether it's an original creditor. So the person who originally gave you the credit, like a Citibank or Bank of America, things like that. Or if it's a third-party debt collector, you might have different laws apply. Third-party debt collectors, some examples are Midland Funding, Portfolio Recovery Associates. There's a bunch of like really small, random third-party debt collectors. And if you're not sure about any of these, like you usually can look at a credit report to see where it's at. You want to look at like what stage you are in terms of collection. So, is the person just starting to get letters? Did they get like just their initial letter saying, hey, a debt collector is trying to collect from you? Or are they post-judgment? Because like the ways that you can deal with that debt are going to be really different based on that. And then something that we look at our firm is the overall amount of debt. Because then you might, somebody may want to consider bankruptcy if they have over $10,000 in debt. It like all of these factors kind of play into it, and it's really like an individualized analysis as to like what your options are. Anything you want to add, Barak?
No, just I guess on that last thing, some people, a lot of clients ask, is there a limit on how much money, how much debt I have to file a bankruptcy? And really there isn't. You can file a bankruptcy for just $1. Nobody would, but you can do it for any amount. So
Yeah, and I mean, one of the things like we'll look at too is like, are you really close to hitting the statute of limitations? Like if you defaulted on a bunch of credit cards, but you're at like 3 years and 8 months, maybe you want to wait it out and see if their right to sue you kind of expires before you consider filing for bankruptcy, because the bankruptcy will likely last longer. What can you do to help these consumers? Like I said, one of the main things that you probably want to do first thing is access and review credit reports. There is a free way to get credit reports. It's called annualcreditreport.com. There's a lot of knockoffs out there, so you want to be really careful and make sure you're going to annualcreditreport.com. And that website will allow you to access free credit reports from each of the 3 major credit reporting bureaus. So that would be Equifax, Experian, and TransUnion. It used to be that you can only get one free one every year from each of these companies. But during the pandemic, they switched to weekly free credit reports and they never looked back. So they're still doing that right now. I just checked this morning. So you can go and like get credit reports every week if you want to. I always recommend looking at all three credit reports because sometimes there are companies that only report to Equifax and it's not going to show up on Experian and TransUnion, for example. And the way that they present information is a little bit different for each company. So definitely take a look. If you're dealing with something like a rental debt or something like that, you may need to look at a more specialized credit report. Uh, and there's all sorts of specialized credit reports for, um, but a lot of times, like we're looking at it in the tenant screening context. So definitely keep that in mind. You can also help people dispute debts on their credit reports. I think the main thing to keep in mind here, when we already went over some tips, is make sure it's not just some generic dispute. You want to put in some reason why you think that you don't owe this amount or you owe less. You want it to be in writing, and you want to make sure that you're doing it in a way that you're going to have a record that somebody on the other side got it. So that could be like through a return receipt, certified mail. Um, you can send it through like anything with tracking. And a lot of times people will ask me, well, can I just do it online? You can, but like generally, I think it's better to do it as a separate letter. That way you have a way to like keep a copy of exactly what you put down. Um, and like, there may be stuff on the online portal that maybe we're not getting. I don't know. I'm very cynical. So definitely recommend sending out letters. Another thing you can do is like review the debt collection letters from creditors and debt collectors. Um, if you see them threatening jail, for example, that's generally not something, I mean, we don't have debtors prison in California, so that's something that would be an immediate red flag if they're making threats, if they're harassing your client. Those are things that you definitely want to look out for. Um, Other things you can do, it may be that your client like doesn't have any money or everything is past the statute of limitations and they're still getting collection letters. You can send a letter to say, hey, stop contacting me. Um, and their debt collectors are required to stop contacting you if they get something like that. Um, if you're getting phone calls, or if your client is getting phone calls, you can tell them to um, tell the debt collectors to stop contacting them. And any of these ways really should stop contact. If they keep contacting them, your clients may have a claim against the debt collectors. You can also send debt validation letters if you need to get more information about the debt. And I think the number one thing is to make sure you're telling people not to ignore collection letters or court notices. A lot of our clients, they don't recognize the name on the envelope. They're like, what's this? I've never heard of Midland Funding. I've never had an account with them. How, what is this? And or they're just like, I've never been sued before. I'm scared of going to court. I'm just gonna ignore this. It'll work out. And usually it's not gonna work out. You're gonna have consequences. Um, like Barak said, they can try to collect from your bank account, they can try to take money out of your wages. So you don't want anyone to ignore these things. There are strict time limits in terms of how long you have to respond or to request information. So it's really, really important that if your client gets anything like this, that they act immediately. Um, and I'll just like put in here, like if you see anyone who is getting their bank account levied or their wages are being garnished, you really, really, really want to refer those over right away. Because those time limits are much, much shorter. I think they've extended them a little bit, but it used to be they only had 15 days to send in what's called a claim of exemption to try to protect their money. So make sure you act quickly. And move on. When should you make a referral? We kind of covered this already, but essentially, if a consumer is experiencing harassment, you may want to make a referral. Definitely, if they've been sued, you want to try to refer us over. The claim of exemption is what we just talked about. If people are getting their bank accounts levied or their wages garnished, definitely refer those over quickly. Also, if your client is interested in bankruptcy, a lot of consumer programs will have, uh, will be able to advise on whether bankruptcy is a good option for your client. So those are all situations there. Let me see. And then referrals. So we've talked about, when should you send people over? Here's where you can send people. So sometimes your organization will have a consumer law team. If that's the case, you can just make an internal referral. If your organization doesn't have one, you can try another nearby legal services organization, a debt management nonprofit. I think like you probably really want to do your research here though, because sometimes you run into shady actors here. The local courthouse self-help center, those can be like sort of hit or miss, but they usually can at least give you the judicial counsel forms that people need to get started. Local law school clinics. So here in San Diego, we have a couple different law school clinics that handle consumer issues. So you may want to look out for those. And also, there is an organization with just consumer lawyers, the National Association of Consumer Attorneys. They also have a Find an Attorney website. So, people may think, well, I can't afford an attorney. A lot of times on these consumer law claims, if it's a good enough claim, you're not going to have to pay upfront. They're willing to take that on and get paid later through an attorney's fees motion or something like that. So that's definitely like something to explore. And it's not on here, but I personally love the Sacramento Law Library's resource guides. They have step-by-step guides to responding to a debt collection lawsuit. Same thing with like filing a fee waiver, doing a claim of exemption. So, if you need information quickly and you can't access any of these other referrals, I would definitely recommend the Sacramento Law Library because I've been able to find almost everything on there. And the best part is like they will have copies of the judicial counsel forms with like they're filled in with little explanation bubbles. So I wish I could show you, but it's not on here. And then resources for advocates, the National Consumer Law Center. This is a organization that basically like compiles a bunch of consumer law treatises. They have a bunch of experts in all sorts of areas of consumer law. So this is a great resource if you have a particularly complicated issue. And they're very generous with their time. The National Association of Consumer Advocates, they have a great attorney referral service. And they also do a lot of trainings and webinars. The Western Center on Law and Poverty, they do a lot of great work with medical debt. The Health Consumer Alliance, this is a great resource if your client maybe isn't like being sued or anything, but they're having like coverage issues, things like that. It's a statewide alliance of like health law advocates. I'm going to leave the 60 Minutes episode to Barak because he did a bunch of research on it. And then also the John Oliver episodes, like he's done a series of episodes on lots of different consumer related topics like debt buying, debt buyers, the property assessed clean energy loans, debt collection in general. So those are usually pretty informative. And Barak, I'm gonna leave it to
I
you
don't know
for
if
the
I did a
60
lot of
minutes.
research. So
More than I
the
did.
so 60 Minutes, this is actually I didn't realize how long ago it was, but it was 12 years ago. Uh, and let me pull up my notes. February 10th, I think, 2013. They did an article on Fair Credit Reporting Act and credit reporting agencies. And back at that time, there were, I guess, about 250 million Americans, and they found there was actually a government report found that there were about 40 million mistakes on the credit report. So, based on that, they found there were 1 out of 5 Americans had an error on their credit report, which is bad enough that 20% of people had an error on the credit report. I mean, we've got 40 people as attendees, so 1 out of 8 of you probably have something on your credit report. But even worse, 1 out of 10 had an error on the credit report that was affecting and might lower their credit score. So, 10% of people at the time had something that could potentially affect their credit scores. Again, that was 12 years ago, but because of the financial reasons for the big three, those numbers probably have not changed that much in spite of the maximum possible accuracy that they're held to.
All right. And that's pretty much our presentation. If anyone has questions, we can take them now, or if you're shy, you can email us later.
There was one question on here that I am not sure about the answer to. COVID-19 rental debts, now consumer debts. Did any legislation extend the statute of limitations on collections?
Um, I don't remember off the top of my head. I do know that landlords are able to go through small claims to try to collect on those, and there's no limit on the amount that they can go after for COVID rental debt. So I'll have to go back and look at that, but I don't remember.
Any other questions? Go back about 3 slides, maybe 4. There's one thing. Okay.
Further?
No. So the cease and desist letters. Um, oh yeah. So I was talking about Regulation X, Regulation Z. So Regulation Z is I pulled this up. Truth in Lending Act. So that's not going to apply to most of us. And Regulation X is the Real Estate Settlement Procedures Act, RESPA. Regulation F is the one that I was thinking of. And that's one. So as far as cease and desist letters, you can also say, look, even though the statute says you can call me between, I think, 8 a.m. to 9 p.m., they're allowed to do that. If they do it before or after without your permission, then it's an instant violation. But you can write them a letter and say, look, it's not convenient for me for you to call me between 8 and 9, but you can send me an email between 5 p.m. and 9 p.m. And then if they do call you at any time, or they send you an email at 2 in the afternoon, that's actually a violation under Regulation F. So it took away some things that we had in California. There was really good case law, but it did add some other things that we can do to kind of stop the phone calls or change the time that they're calling and make it a little more convenient. But you can also at any time send out a cease and desist letter saying, don't call me, don't write to me, I don't want to hear from you ever again. And there's just 1 or 2 things that they can do. They can, send one final letter saying, we got your letter, we're not going to call you anymore. But the debt validation letter can only be sent within 30 days of when you get the initial debt collection letter. You can still send it after that, but they're not required to reply to that. So, and I think that was everything I want to talk about.
Yeah. Also with the Fair Debt Buying Practices Act, you can make a request for additional information too. That's part of the statute. And they have to include that in the notice they send to you. So Just because you miss this deadline doesn't mean you'll never be able to get information about the debt.
Hi, guys. I was just going to mention, I was looking up the COVID rent debt, and it looks like the same there was some tolling, I think, but the same statute of limitations apply. And I don't usually rely on the California.
Lastly, no, well, we're not going to know what Lee doesn't like to rely on.
Okay, well, hopefully she'll come back. But I don't see any other questions for now.
I think we're going to give everybody a little less than 3 minutes back of their time.